Hello, I'm Robert Eckersley, Denodo's Director of Partner and Channel Sales. The short video you were about to see is an excerpt from a recent 1 hour webinar, Fast Track to Law 25 Compliance. Key components of Law 25 go into effect in September, which govern the protection of Quebec residents' personal data. Will your organization be ready? I welcome you to watch this excerpt, or better yet, click on the link in the description below to watch the entire webinar to learn about the fastest solution for Law 25 compliance.
In many ways, GDPR is kind of the guideline for what's happening here. That went into effect in Europe, I think in 2017, and Law 25 in Quebec and the provisions for C27 that we expect to have hit the rest of Canada soon are in large part based on the framework that was put in place by GDPR. And it was very interesting to see how companies progressed on their journey towards GDPR compliance in Europe. Many companies were a bit slow at first, were not prepared at the deadline, but it turned out the regulation really had teeth. And a lot of the work, Denodo did a lot of work and made a lot of sales around GDPR, but a lot of that work was actually after the deadline. And what happened was that, the regulators started fining people. And it's been very interesting to look at the progression of those fines. Here's some information I got from a GDPR blog. There's been a lot of notable GDPR violations and large-scale fines, and they've been growing as the years have gone on. So there's been more than 50 of over 500,000 euros. The largest was just set very recently this year when the US company Meta was charged 1.2 billion euros of violating GDPR laws. They were transferring data out of the EU to the US. There's been a lot of notable ones from companies of all different types. You can see ones here by British Airways, Marriott, Vodafone, all of which have been fined for not protecting their customers' data. And what I found is as time goes on, the fines are getting larger. So there's both fines and obviously reputational risk of not looking after and safeguarding customer information. So the next thing we'd like to do, I'd like to pass things over to Mark Rowan, and Mark is going to take us through some of the provisions of the law itself. Over to you, Mark.
Thank you, Robert. We'll dive into a little bit about Law 25, but before I do that, a little bit of a commercial for C27 and what we foresee coming out at a national level within the Canadian marketplace. Someone could correct me, but last time I checked, C27 was in committee, which ultimately means it's moving down the line fairly rapidly to becoming law. Nobody really knows exactly what will be in C27 when it does come out, but we're anticipating it's going to be somewhat similar to Law 25 in Quebec, GDPR in the European market, CCPA within the Californian marketplace. The laws around the world tend to be somewhat similar. Data privacy laws I'm talking about specifically. And Law 25 is not all that unique when you start to look at the various different laws, country by country, region by region around the world. Then they're in place to protect the information assets that are provided by individuals to entities or organizations, companies, governments, etc. And the basic philosophy behind that is that the individual, the consumer, owns their data. And they're providing that data to an organization or an entity with specific permissions and rights that they're going to maintain when they do that. So the organization that's going to take that data has to have consent from the individual under these laws to use that data specifically for the purpose with which they collected it or what they told the consumer they're going to collect it for. And that kind of consent is an important facet of the law. And it does change how we manage our businesses and deal with individuals. Because at the end of the day, the individual owns the data and they have a right to govern the use of that data within the organizations that have been granted the right to be able to maintain that and use it for a business purpose. And of course, then there's the consequences of not complying with these various different laws. And there are a number of them. Obviously, there's fines embedded in these laws. So the laws have teeth. And as Robert was saying earlier, we've begun to see a significant pattern of regulators enforcing the laws. And we would anticipate that that will be the case here in Canada. But the other consequences that we need to be concerned about are things like litigation. And we've seen that evolving around the world around the concept of mass torts. And we've obviously seen that in Canada a few years ago with a particular incident that occurred in our marketplace. So it's not unseen in the Canadian market that these types of things can occur. And the third risk is really around reputational damage. If your customers know, or it's in the press, that you've had an incident and that you didn't comply with the law, obviously that can have a negative impact on your organization. Diving in a little bit deeper, let's talk a little bit about organizations have to comply.
One of the things that we identified up front, is that this can be an overwhelming task. There is so much data and there is so little time. And the way in which you, I guess, combat those two things is two things. One, you have a proven process, a methodology that gets you from I don't know how to start right the way through to finish, and substantial automation, which is what takes time out of the equation, because so much of this we have found ways of being able to automate. So let's take a look at what the joint solution looks like. There's a lot of key capabilities I've got listed on the right-hand side here.